All right. Article 61 says that you have to provide criminal procedures and penalties for trademark counterfeiting cases. You have to provide sanctions, which must include imprisonment and or all monetary fines. And these sanctions must be sufficient to provide a deterrent. Okay, so all countries who are parties to WTO has to follow this minimum standard. You have to provide all this in your laws. So we look back at China. The Trademark Law 1982 does not provide for criminal sanctions for trademark counterfeiting. The provisions are provided in the Criminal Law of People's Republic of China. But in preparation to accede to the WTO and automatically be bound to the TRIPS agreement, China introduced laws, regulations to ensure that their laws satisfies the standards in the TRIPS agreement. Okay, for example, they introduced special rules for the criminal sanction on counterfeiting of registered trademark 1993. Okay, this is way in advance before they signed the WTO. They acceded to the WTO in 2001. Yeah. Now, in 2007, there was a complaint lodged against China at the dispute settlement body in WTO. The US complained that Chinese criminal enforcement provision for trademark counterfeiting does not satisfy Article 61 of the TRIPS agreement. The US says that, look, for example, Article 213 of the Chinese criminal law. It says that counterfeit trademark, use of counterfeit trademark is a criminal offense if the circumstances are serious. What does it mean by circumstances are serious? Now, the Chinese judicial interpretation regulation says that it is considered as serious if you obtain a profit of a minimum 30,000 yuan. US argued that, so you are saying that if you get profit, then it is considered as a criminal offense. But what happens if it is a charitable organization? You don't get profit, but you manufacture maybe t-shirts with Levi's logo on the t-shirt and say that, look, this is original. So this is counterfeit at a very large scale, but there was no profit involved. So in this kind of circumstances, based on Article 213 and the judicial interpretation, this is not a criminal offense. So US is not happy about this at all. But what makes this interesting, this particular case interesting, is that for this particular point, the panel body says that, look, US has failed to prove that the Chinese criminal law does not satisfy Article 61. Okay, so for this particular claim, the US failed. Okay, but what makes it interesting is that you can see the diffusion of Western trademark standards into modern China. First, by way of multilateral trade agreement, yeah, the TRIPS agreement. Then, by way of dispute settlement body. If I'm not happy with your provision, I can complain to the dispute settlement body, then we can talk about it. All right? And informally, the Chinese government officials were exposed to the standards when TRIPS agreement was negotiated and drafted. And the Chinese government officials were the ones who were preparing papers to counter the US's complaints. In order to be able to successfully counter US's complaint, you have to be very, very well versed with the standards in the TRIPS agreement. So again, you can see here the diffusion, the workings of Western trademark standards in China now. All right. let's talk about today. We are talking about digital world. We are talking about borderless world. Before this, all our examples, our case study of Qing Dynasty, of modern China, we are more or less talking about formal diffusion. Yeah, we are talking about diffusion among officials, among governments. Yeah, but in a digital world, anyone can be an agent to diffuse laws, concepts, norms. So it makes it, the rate of diffusion is maybe as fast as lightning speed. Okay, and how do you track where did this originate from? It may be very, very difficult. Everyone has access to the internet. Everyone has access to news or laws or customs from all around the world. It would be a tough job. Yeah. So thank you very much for listening to my presentation. That's about it, about the trademark and in Chinese, in Qing Dynasty and China. Thank you. I look forward to listening to any questions if you have.
Hello, am I audible? Hello? Yes. Okay, thank you so much. First of all, thank you so much for invitation to speak at the conference today. It's such an honor for me. So I have around 15 minutes, so I'll try to finish my presentation, to wrap up my presentation as fast as possible after delivering a very short and brief key points of my presentation. So I chose the topic for a presentation today on the issue of maritime security in the 21st century, the position of Myanmar. So the content of my presentation will cover, first we're gonna look at how do we define maritime security. And also before we go for an individual country, we want to look at the regional scope of maritime security, which is of course ASEAN, which is very much relevant to us. And maritime security for Myanmar's position and what would be the way forward. So first, we have to define maritime security. So we want to look at the international perspective first. Whether do we have universal definition, universal consensus on what maritime security means? How do we define it? So the answer is no. No universal definition yet. So maritime security is one of the latest buzzwords of international relations. So it's pretty much used very often in international relations and policy making, according to Professor Christian. Maritime security issue has become salient only after the September 11 terrorist attack in the United States. So after 9/11 attack, these issues becomes more popular among the global community. And so this September 11 attacks kind of like stimulated the awareness of the security issues at sea. So there can be various definitions depending on the person who defines it, depending on the background. If the person is from looking at from the shipping industry perspective, they might look at the safety of the ship, safety of navigations. And if they are looking at from the national security perspective, they might be looking at from like warfare, naval warfare, maritime power, etc. So generally, regardless of the different perspective, looking at what maritime security means, we can generally categorize into two types of security threats. What kind of crimes or threats happening in the sea? So the first type would be conventional threats, which pretty much everyone aware of since the history, like wartime threats. So even when we look at the World War I and II, there are also war fighting between the naval forces. Yeah, that would be categorized as conventional threats, and the contemporary threats can even present during the peacetime, not only the wartime. So next, for the purpose of this presentation, I'm going to focus on contemporary threats. So what are the security threats in the 21st century maritime environment? Of course, with the advancement of technology, the threats and the nature of the crimes also become more complex and more sophisticated, the methods that they commit such crimes. So the first will be piracy and maritime terrorism. Also,
kalau yang kelasnya HKI udah ada.
Sorry. So the third type would be trafficking of people and narcotic drugs and other illicit goods, and also arms proliferation, and also very which is a notorious crimes called illegal fishing, where all countries are losing millions of dollars annually, and boundary disputes and sovereignty claims, for example, like South China Sea disputes, and environmental crimes or maritime incidents and disasters, and also the most recent discussions would be the cybersecurity issues in the maritime domain, and also, of course, not to forget the port security, because port infrastructures and facilities are also very much important for the maritime supply chain. And so these are some of the illustrations for maritime security threats. This is how maritime terrorist attack occurred, and piracy. And this will be the marine pollution and drugs trafficking, illegal fishing, and human trafficking. So this is also one of the recent discussions, which is autonomous ships. So this is also because outcome of the advancement of technologies that now ships are becoming autonomous, which is there are also, of course, different level, fully autonomous, semi-autonomous, where the human interventions is still involved for some of the functions. So currently, more than 1,000 autonomous ships surface ships are operating by more than 53 organizations. So if we have the new issues and also new threats in these modern days in every sector, that we need to think about as government and as authorities, how do we control, how do we manage, how do we regulate, right? So that would be the very first questions: that are we ready? Do we have enough regulations to govern such emerging issues? So currently, even at the international level, we do not have the comprehensive, or we do not have regulations for autonomous ships. So these autonomous vessels currently working alongside manned vessels with minimum autonomous specific regulations. And for this, IMO, International Maritime Organizations, is working on developing the regulations over the autonomous ship. So since I have very short time, I don't have time to go deeper. So I will just be to discuss just briefly on every issues. And next is one issue with the autonomous ship. How do we regulate it, right? And another issue is, just now I mentioned about maritime cybersecurity. So with the advancement of technology, again, now the ships are more connected. More ships are connected to internet and satellites, and so that more they. And not only they are individually connected to the internet, all the ships navigating in the sea are also connected in one way or another. So this is also one of the outcome of modern technologies. And as you all aware that there is no such thing as boundaries for the internet, right? So even now, although we are speaking from different jurisdictions, we are just it's sort of like face-to-face conversations that we are having. So it's very difficult to detect if someone is interrupting or hacking into your system network facilities and disturb and interrupt with your functions, normal function operations of the ships, maneuvering of the ships. It's very hard to detect. So this is still an emerging security threats, and we need to test the resilience, how resilient we are in terms of this emerging cyber threats in the maritime domain. So this is also can be one of the examples that I'm showing into you on the screen. Suez Canal blockage, just last year it happened. And although it is not the confirmed reports that it caused because of cyber attacks, but there are many speculations that it could happen because it could have happened because of the cyber attack. And what is the impact that if you want to look at, because of these emerging threats, because the ships this ever even was stuck as shown in the photo here, another 400 vessels scheduled to pass through the canal was blocked. And about 12% of global trade, around 1 million barrels of oil and roughly 8% of liquefied natural gas pass through the canal each day. So all those vessels were stuck and they couldn't pass through the canal because of these ships. And the loss would be USD 15 to 17 billion has been held up. So such a major impact because of the emerging threats, cybersecurity threats in the maritime domain. So the expanded range of maritime security threats poses serious risks to the safety of the ships, the ports they sail to, and the persons aboard them, as well as added danger to the cargoes they are carrying. So I just want to briefly touch on the ASEAN. So now as a regional organization, what ASEAN is doing. So ASEAN also doesn't have ASEAN has given its interest on the maritime security, but still it has yet to come up with the definitions for the ASEAN. And what makes ASEAN to take interest in maritime security would be the issue of piracy and because of IUU fishing. ASEAN has no official definition yet, and different group of ASEANs are working on the different sectors of maritime security. So we have yet to come up with this inclusive plan of actions as ASEAN to combat emerging or contemporary security threats in the maritime domain. And questions for ASEAN, so we have to ask, is the action plan ready? How to ensure inclusivity as a regional organization? And sometimes it's very difficult to have the consensus or a uniformity among all ASEAN members. Reference would be, you might want to look into the South China Sea disputes and the code of conduct. So the main points of my presentation here is a Myanmar maritime security landscape. So I will skip this. You can Google it later on where Myanmar is, and probably most of you already know where it's located. And so for Myanmar, same thing, for no definition for maritime security, and it has two key non-traditional or non-conventional maritime security issues for Myanmar. So they are maritime asylum seekers, arms smuggling. An issue of asylum seekers at sea, the trafficking of humans, arms and drugs. Arms smuggling is a serious problem for Myanmar, as the border area between Bangladesh and Myanmar is a sanctuary for arms smuggler, mainly due to its extensive coastline and weak maritime surveillance capabilities. So smugglers ship various types of small arms from Thailand and other Southeast Asian states and transit through these waters to sell them to insurgents in India, Bangladesh, and Myanmar. So role of Myanmar Navy and law enforcement, Myanmar being many of the years under the military rule, so Navy was the main law enforcement body. So since 2008, Myanmar has steadily modernized its Navy through a mix of domestic manufacturing and acquisition and development of frigates, corvettes, and missile crafts in domestic shipyards with foreign assistance, especially from China. The Navy aims to become a blue water Navy in response to regional naval modernization and to protect its long coastline and extensive exclusive economic zone from both state-based and non-traditional threats. So traditional security concerns are the defense of sovereignty and territorial integrity from external powers. It has driven Myanmar's naval modernization ambitions since the turn of the century, such insecurities peaked in 2008 following a clash with the Bangladesh Navy over disputed maritime borders in the Bay of Bengal. And we can see that Myanmar is very close to China. So China investment is huge in Myanmar. So China too has high stakes in Myanmar's strategic location, having invested significantly in Myanmar's maritime infrastructure development. So as you can see that this is the Chapchu in Rakhine. China invested the US 7.3 billion deep sea port. So it's one of the major China investment for Myanmar, and geographical situation, the porous border between the land and the sea creates the opportunity for smugglers, traffickers, and insurgents to resupply and reinforce their land-based operations. And inland drug trade routes and insurgency areas of operations addresses this interconnected nature of maritime and coastal crime. So what we can see is that whatever happens, the crimes on land can also extend to the sea, because most of the crimes are transnational in nature, and they will be using the maritime transportation in committing such crimes. So maritime enforcement efforts have nominally been subordinate to land-based operations of the army. That's one of the weaknesses. Give more priority to the army than the navy. And these are, Myanmar has now 2 submarines. The first submarine was received from India in the year 2020. And a year later, they received another submarine from China in December 2021. And Myanmar became the first Southeast Asian country to take delivery of a made in China. So this is purely made in China submarine, although we don't know how long it will last. And this is the recent development. Myanmar's already formed a Coast Guard agency to launch the Coast Guard. The launch of Coast Guard was on October 6, 2021 at Tilawa Port in Yangon. Currently, it has 4 vessels. Definitely, it is not enough. Proposed functions, search and rescue, environmental protection, law enforcement, and many other functions they have. So the question is that, what is the future? How do we ensure that the newly formed Coast Guard can cope with all the ongoing challenges in the maritime domain? So as a conclusion, so generally, not necessarily for international level, regional level, or individual countries, whatever it is at any level, the very important points are piecemeal approach to holistic approach. So rather than we have different sectors and agencies working on their own, we need more integrated efforts of different sectors come together, sit down and brainstorm how to, combat and against the ongoing challenges in the area of maritime security. So we have to move from exclusivity to inclusivity. And I would like to end my presentation with this quote: diversity is the mix, inclusion is making the mix work. With that, I would like to end my presentation. I'll be happy to take your questions after this. Thank you very much.
All right, thank you very much. Can everyone hear me? Yes, all right, okay, thank you. Okay, so Assalamualaikum to everyone, and thank you for inviting me for this wonderful conference. I've learned a lot from the first 3 speakers as well. My topic is a general one, basically with regards to cybersecurity in Malaysia, because the theme here is about the digital era. And just like what Prof. Mashkuri said, I also believe that as long as you follow the Islamic teachings, it shouldn't be between laws and how we approach cyber laws, because the concept is there. As long as you actually follow and be a decent human being, I mean, it's all there. So cybersecurity here, basically, it has become a huge issue and a very big thing, especially after the COVID-19 situation where everyone started to be connected. Things which were before not relevant or seen as something not substantive, it has burst in the past 2 years. So it has become a necessity. And even though now we're coming out of it, the way that we connect online is far ahead than it ever was 2 to 3 years ago. People are becoming more reliant on the social, the big data, the Internet of Things, artificial intelligence, and even hyperspace cloud. Just as was mentioned, we've got the fourth industrial revolution, although now we're looking at fifth. But you can see even the younger generations, online presence is as important as offline presence. So this is just one of the things, but hand in hand with this is with regards to the other side or the disadvantages of such connectivity and such a reliance on internet, where we have cyber crimes. For example, in Malaysia in 2022, or no, it's right, 20 like that, 20,000 cybercrime cases with losses amounting to 560 million. That's huge. And this is expected to be even bigger as it goes along. And so we have to look at how to protect our country is one. And it's not just from one scale, it has to be from several layers. So the cybersecurity strategy in Malaysia is twofold. It has to be pragmatic, where you're actually aiming for a cyberspace that is secure, trust, and resilient, yet at the same time, you have to foster economic prosperity. Overseas or international, they want to check if they want to actually do business here, are we actually protected? How well is our firewall? How well is, do we actually, how secure is our internet? So the 2020 the biggest in terms of what sort of cyber incidences we've had, and this deals with fraud. And you can see that until September, we don't have October's data yet. It comes to at least 400, and it goes a lot as it goes along. So we do need a very good cybersecurity strategy. And in Malaysia, basically it's looked at 5 pillars. These are the strategic 5 pillars. I'll be going through these 5 pillars quickly, just focusing on those which, for example, on law, etc. Right? So the first pillar is with regards to governance and management. Second, we have to look at the law. The third, we're looking at research, industry, the technology, how to actually improve it. The fourth is with regards to awareness and education. And fifth is strengthening global collaboration. As you can see, to actually have a good cybersecurity or to actually secure your internet presence well, it's not just the people, it's not just the technology, it's everything together, working together, hand in hand and overlapping. So you have all this which must be done at the same time. It cannot be just looking at how people would react, how people would do, but at the same time, without that, you can't actually protect properly. So the first is with regards to governance and management. Of course, this is number one. Without the head, how are we actually going to make sure that everything is streamlined, how everything is actually done properly? And here in Malaysia, for example, we have the National Cybersecurity Agency, or NACSA. This is our biggest, our main cybersecurity protection agency, as you can see, in a way. It is the agency which will oversee all national cybersecurity functions, and it is the one that will actually be able to monitor and control. We've got so many fragmented agencies and NGOs and companies, so you need one central head, and this is what NACSA is all about. And we have another, I'm going through the main ones in Malaysia. We also have the Malaysian Communications and Multimedia Commission, which is dealing with the regulation of communications and multimedia industry. Now, typically when it comes to the internet, that means anytime you want to be connected into the Malaysian internet, you have to get a license from the MCMCs. And in that way, they regulate the people who actually provide content services or service providers, right? So your telco will go through MCMC. Those websites will have to go through MCMC. And with MCMC, they are the ones, they have the Multimedia Commission Act, which they have the power over. So if there's anything that people are acting online, which is infringing, MCMC is the one that will come in, and or one of the agencies that can come in and actually protect the people. And for that, we also have what you call the content code. Now, this is a voluntary content code, which actually has the content as in the way people are supposed to conduct online. Now, it's voluntary for users, but for those who actually have a license from NCMC, it's compulsory for them. So that's in one way how it can actually be regulated. The act will only be an overall situation, whereas the content code is more specific. It defines things like what is actually bullying, what is actually fraud. And it recently went through an amendment whereby it also now includes online marketing, influencers, because situations where they see people, influencers, are under the mistaken impression that they are not liable for anything if they advertise or if they actually promote something, because if they don't actually use it, they're actually, all the laws that are applicable to offline advertising and broadcasting, it also applicable to them, but they do not realize this. So the content code actually defines it, makes it clearer, and it regulates people more. So you don't have things like people who are actually promoting something they have no idea about, or people who are actually having fake reviews, etc. So all this the content code will cover. And we have the cybersecurity, which is actually an organizational body. And here is where it is now, as of 2018, it used to be an independent company separate, but now it is under the Minister of Communication and Multimedia Malaysia. This agency is actually one of the main agencies which provides help, technological help, digital evidence, and any sort of help in terms of, if, for example, when we had ransomware, cybersecurity actually provided aid in how to actually get rid of the ransomware and protect the people under it. So we have these agencies, and we have the command center, NC4, National Cyber Coordination Command Center, which is the main one, deals with cyber threats and crisis at the national level. This is the head. It is under the purview of the NACSA, and you have many other divisions as well. You've got 4, which is the MCMC Network Security Center. You have the Government Integrated Telecommunications Network. You have the Cyber Defense Operations Center, and you have the Cyber Security Malaysia itself. So these 4 organizations are under the NC4, where will make sure that it protects Malaysia itself from cyber attacks. The purpose is to detect, to trace, and to protect. So this is what NC4 also does. So that's the first part, the management. So these are the bodies which are there to oversee and protect the nation, Malaysia, as a whole. Of course, with that we also need the laws. Now, this was the very first cyber laws in Malaysia. You got the Digital Signature Act, the Computer Crimes Act, Telemedicine Act, which even until now is not yet enforced, the Communication and Multimedia Act, where the MCMC gets its power from, and the Personal Data Protection Act. I put that in italics because it was actually created in 1997, but it took a very long time before it was finally passed. That's why until 2010, it took over like nearly 10 years actually. They were trying to put it out in 1997, but couldn't until 2010. Digital Signature Act is basically a cryptography punya system where you will recognize a particular signature as formal. Computer Crimes Act is the main one now, deals with hacking or any sort of computer crimes. Telemedicine Act is meant to be able to allow hospitals and healthcare providers to actually provide care, even surgery online. But as you can tell, it's not yet enforced because there are so many nitty-gritties there. Ever since then, we've had a lot of amendments or a lot of new laws, like the Electronic Commerce Act and the Electronic Government Activities Act, which is actually more or less the same. It's just that the first one deals with private individuals or organizations, whereas the second deals with the government, but both deals with using emails for business. Whether it's actually something which is applicable, it is voluntary, but once you agree to use emails, like you send contracts through the email, then this act will start to apply. And then as it goes along, people start to realize you don't need to create a specific law on cyber issues. You can have, or you can interpret existing laws and apply that online. For example, the penal code. And there have been amendments to existing laws to incorporate cyber issues. For example, the Evidence Act, where Section 114 basically talks about there's a presumption that you are the one who actually posted the post in any, if it's under your account. So the presumption is already there. You're presumed guilty and you have to prove yourself that I'm not the one who did it. Copyright Amendments Act, the Sedition Amendment Act to include online activities. And we do have the Mutual Assistance in Criminal Matters Act 2002, where, as you know, when it comes to online, it's not national, it's international. Most of these people do not hack from within Malaysia, or there are some in Malaysia doing it outside. So you need international cooperation, and this act actually fosters that sort of collaboration and cooperation. The law is one thing, enforcement is also another. It has to come. We have to enhance the capacity and capabilities of our law enforcement. So you have the National Cybercrime Enforcement Plan, where you want to increase knowledge and skills of judiciary members, prosecutors, law enforcement officers, and legal practitioners. If you don't know the law, it's not just knowing the law, it's actually knowing internet aspects, knowing what is it like online, knowing how it actually works online, and how to interpret the laws in accordance to that. So if you don't have skilled members with such knowledge, you're going to come up with very weird laws, like it did in the beginning when they were trying to interpret certain aspects, which I don't need to mention here, and it goes along. Fortunately, it has improved a lot. We even have now cyber courts, which was first created in 2016. We have both criminal court and civil court, but unfortunately, due to its difficulty, we only have, it was only created in Kuala Lumpur, Wilayah Persekutuan, in one state, so we don't have that many cases heard by the cyber courts. It's still heard by others. But we do have one now just also open in Johor. You can see the main one. So otherwise, if it's not, they'll still be heard in normal courts as well. For other efforts, we have the AGC still looking at all the laws and how to actually enhance the existing legislative and regulatory frameworks. We also have NACSA coming up with a cybersecurity bill. It is touted to be passed or to come out in January 2023. It will be to study and create a comprehensive cybersecurity law that will enable NACSA to better protect Malaysia itself from cyber attacks. And I'll just go through this one due to lack of time. Basically, it's the same thing. We've got national policy, closely guided national security. So a lot of issues there. So the law is not just having the law. We also need to be able to enhance the law enforcement. Even the police, the Royal Malaysian Police, they do have a commercial division that deals specifically with cybercrime. And for them, they go for courses to further enhance their knowledge in IT. Because when you come to trying to gather evidence, they have to make sure that in their gathering of evidence, they don't accidentally destroy the evidence. Because when it comes to online, doing certain things wrongly, you may accidentally delete the equipment, etc. So that's the difficulty they have as well that's being covered. Technology is another. It's not enough. You need to be able to always improve your technology. So there's always research here. For this, we have Mimos Berhad. They actually focus on generating technology because this is their area. So they have been tasked to actually further look into this, further develop. And the key areas of research and development is, number one, is privacy. Because everyone knows when it comes to privacy is out there. So digital signature, digital identity, so that there's no identity theft, entity authentication, encryption algorithm, and cyber physical security. The encryption, you know how difficult it is to actually have your passwords can be hacked. The Fourth pillar is enhancing capacity and capability building. This is also overlaps with the earlier law enforcement, can fall under here as well, in terms of increasing knowledge. But it's not just there. This one falls under everyone. It's not just those in the area. It deals with the citizens, it deals with everyone, because how you actually conduct yourself online is another layer. You cannot depend everything on the government. You cannot depend everything on the law. It has to come from you first. The others are the ones to help protect your rights, but you yourself must be able to know what to do in order to protect yourself. So this is where you have to enhance not just awareness, but you also have the education. So there's been a lot of awareness and education activities by the government and by NGOs and by concerned parents, etc. So Cybersecurity Malaysia, for example, they did a fresh baseline study to assess the level of online safety awareness, and the data that came back was not very good. You could see that a lot were unaware what they're doing is actually very dangerous, especially when kids are playing online, for example, online games. They think they're anonymous, but not necessarily. They may accidentally give off information, private information, where other people, if they're targeting you, they can find out. So these things, when you take photos, make sure you take off the location. When you post your photos on WhatsApp or YouTube, or even nowadays IG, TikTok, etc., make sure that it is something that cannot actually identify where you are. These are the things which they have found out. So things which they actually want to make sure, one is to make sure that all the agencies, all the companies, actually the critical national industry infrastructure especially, comply with the ISO, which deals with information security management system standard. You have to have the proper equipment, proper security, proper knowledge. Another is they also had this, what you call cyber crisis exercises, where they simulate how it's like. What if it happens? What if there's a cyber crisis? How are you actually able to address it? Do you have the proper response? Does the national agency have a proper response? Does the company have a proper response? They've had so far 6. The last one was in 2017. And in that one, they had the most. So this is just a brief data where I got it straight from the cybersecurity strategy itself. In 2008 was the first. There was only 10, and it went up exponentially until 2017. There was about 100 agencies who actually participated in this exercise. And this how it can actually improve. So you can see by the number from 10 to 100 how agencies are becoming more aware of the dangers and becoming more prepared to face these dangers. And of course, you've got awareness. You have NACSA, who's also developing the National Cybersecurity Awareness Plan. It started in October 2017, and the 4 target groups will be kids, youth, adults, or the parents, and organizations. So they have to make sure that they are the ones who are aware, especially kids. Now you can see 2-year-olds, even with iPads, so connected to the internet. What sort of things are they watching? What sort of things are they revealing? So the adults must make sure that when they give their kids this sort of technology or access to the internet, are you aware what they're doing? You cannot just give and then not be there. Youth, a lot, online presence is as important to them as an identity. They get validation from online, not so much presence, online verification. You can get slandered, which is the downside. So all these they have to know. CyberSafe is one program by cybersecurity which aims to create such awareness. So they do go to schools sometimes, besides providing the booklets and awareness for kids and adults. Sorry, they also try and create, they go to schools and give some sort of, you can be invited to schools to give talks on the dangers, etc. So the schools are also the targets, this one. when I say schools, will be primary schools and secondary schools. And they're also aware now that when you want to make people aware, using the old school method of, for example, newspapers may not actually generate or create proper awareness, because people are connected online. You have to go through social media. You have to go through IGs, get influencers. So that's what they're doing now. This goes on the radio. You got people actually making short notices or short awareness programs where people are start aware, and it has shown some benefit, because from a study, it showed that the number of cyber crimes incidences, for example, where you click and you get scammed, has reduced significantly due to this sort of awareness program. People are being more aware. Don't just mind click. You have to be aware of how you click. You have to understand how it works. And it's also found that most of the scammers is not an individual. It can be organized crime. It can be something which is actually big issue. I mean, previously the Nigeria scam was one of the biggest thing. They have evolved as they go along. So these people evolve, the criminals evolve, society has to evolve as well to be aware. So the more aware people are regarding the methods that scammers use, the more difficult it is for them to actually be able to target people. And so last, which is the one I'm not going to go through, essentially global collaboration, where you don't work by yourself. You actually need to have international cooperation, international collaboration, because sama-sama we understand with cybersecurity affairs, it's not an internal thing. It's not an inclusive thing. It is wide mix. And that's it for my presentation for the cybersecurity. Thank you very much. So
Thank you, Mr. Moderator. Right, the question of how to regulate trademark counterfeiting in China is actually a worldwide problem, how to regulate trademark counterfeiting. Everyone faces the same problem, and every country, the governments have introduced numerous laws, enforcement measures to counter trademark counterfeiting. But in China especially, they have also introduced this new set of rules to strengthen the intellectual property protection, the trademark protection in China. But the question is actually more to how do you enforce these laws? This is really dependent on the enforcement body. We are talking about the police, we are talking about the intellectual property office. We are talking about, do they see it as an urgent measure, as an urgent problem? Or are there other problems which is more important, murder, whatever, commercial crime, as opposed to trademark counterfeiting? So if these individual agencies feel that trademark counterfeiting is not as important as other measures, other problems, it would be difficult. Even if there are laws, they may not be enforcing it 100%. So we can't really say how do we increase protection for against trademark counterfeiting? Thank you.
organizing committee asked me to present about the constitutional rights on the freedom of speech in the digital era. So constitutional rights on the freedom of speech in the digital era. So, and this is very important points that now that of course that maybe all of us agree that the freedom of speech is important and should be protected. And almost all constitution over the world provided that the freedom of speech is a constitutional right and should be protected. So, but at the same time that there are quite how the heated argument, controversy about whether that how to say the freedom of speech, especially in the internet or cyberspace, should be protected as before, because of the how to say there is a rampant how to say very often abuse of those freedoms, such as hate speech, fake news, or how to say propaganda of war, or other manipulation of some information. That's why that many people, or government, even government, how to say, consider that the freedom of the speech in the cyber area should be restricted than ordinary freedom of speech. But I wonder is the correct argument or not. So, and even that the speech is made in the cyberspace or real world, it's a speech is speech. That's why that the first we should think about the what is the traditional protection of the freedom of speech at first, and what condition that those freedoms should be regulated. And after that, I will discuss about the one very traditional area where that how the freedom of speech is more regulated, restricted than printed or traditional how to say expression. This is meaning the broadcasting. And then that I move to the freedom of how to say, as a conclusion, I will discuss some how to aspect of the freedom of expression in the digital era. Okay. So this is the contents of my presentation today. First, why is freedom of expression is necessary? So maybe you have to think from this that if the a freedom should be protected because that freedom is important. So no one has the freedom to kill someone because that the freedom to kill is not important. That's why it's not protected. And the malice of freedom of kill is more severe. That's why that the freedom of kill is prohibited. That's why that if the freedom protected, that means that this freedom is important. So maybe we should think about that. And in order to think about this point, that I will review the traditional understanding of the freedom of expression. And I just quoted the very well cited work by the Thomas Emerson. He is a US lawyer, and he summarized the values of the freedom of expression from the United States jurisprudence, especially from his how to extended work review of the Supreme Court of the United States, Federal Supreme Court of the United States. And he said that there is a full value of the freedom of expression. First, it's freedom of expression as assuring the individual self-fulfillment. Second, as a means of attaining the truth. And third, as a method of securing the participation by the members of the society in social, including political decision-making, and as a maintaining the balance between stability and change in the society. So first point that the freedom of expression as an individual self-fulfillment is that it's a matter of the, how to say, right to personality. So everyone has a, how to say, the freedom to express himself. So if I want to be a painter, so I should have the right I should have the freedom to paint. And if I want to be the novelist, I should have the freedom of writing novel. Or if I want to be a singer, I should have the freedom to sing. So maybe that this freedom is to, how to say it, realize my personality. This is an inherent right for the humankind. So maybe this is one of the most important value of the freedom of expression. But the freedom of expression is not only self-fulfillment, but the freedom of expression has the social aspect. So that the point 2 and point 3 and point 4 is that maybe can be summarized as a social aspect of the freedom of expression. The first is as a means of attaining truth. And this aspect often calls the free market of the information. If there is many information or many expression that it's how to say it, there is competition amongst contradicting information, and only true information or true opinion may, how to say that, sustain within this competition, and humankind can attain the more truth fact, or that the more strong opinion. So, and through this competition that the humankind can develop ourselves through the competition of the, how to say, through the free market of the information or free market of the opinion. So this is the second point. And the third point is the democratic aspect of the freedom of expression. So that according to this point, that the freedom of expression is necessary or indispensable for the democracy. So when in the election, that the voters have to choose that to vote which candidate, but in order to decide the candidates, so we have to know about the information about the candidates, about their policy and their, how to say, the personality, their background, and their possibility to be a good politician. So that without those information, we cannot choose the candidates, or that how to the political party to support. So, and of course, that how to say criteria to choose is depend on the voters. So maybe that I'm concerned about their political integrity, but others concerned about their religious strongness, or others considered whether he or she is a good parent or not, or others considers maybe that their appearance, handsome or beauty or etc. It's how to say so that the need for the information about the political candidate is huge how to say vary from person to person. That's why that there should be the much free how to say information as much as possible in order to, how to say, activate the real democracy. Without such a, how to say, adequate information, that the democracy can be called the only the semantic democracy or democracy, fake democracy. So this is a third point, that the freedom of expression is indispensable for the democracy. And the fourth point is how to say, freedom of expression to stabilize the society. Maybe it's the freedom of expression for peace. So that this is if the one expression or one opinion oppressed and other is only, how to say, allowed, maybe that oppressed, the people who have the oppressed opinion have to express their will in other way than expression, maybe using the violence. So if the people who are oppressed using the violence, it's the, how to say, destruct the social peace, and then that the democracy and the stable society will be damaged. That's why that with the freedom of expression is very important to maintain the balance between the stability and change in the society. So this is Thomas Emerson's summarization about the importance of the freedom of expression. Okay. So, but of course, that the freedom of expression is not unlimited, and maybe since old age, there are a lot of the limitation, restriction over the freedom of expression, such as there is many reasons, such as the defamation. We have the freedom of expression, but we don't have defamed the good name of the other people, because fame is a very important property belong to each person. So that's why that this good name or fame should be protected. Or how to say, obscene expression or pornographic expression should be restricted for the good of the how to say that social morality or social order or protection of the child, etc. And also the danger to the public safety, such as state secret or how to say political how to say another how to say propaganda for the violence or privacy should be protected. How to say should be protected. That's why the how to say danger to the public safety is traditionally become the reason for the restriction of the freedom of expression. And maybe that those reasons are specifically for the freedom of expression. But also there is a very universally recognized general reasons, such as expressed in the Universal Declaration of the Human Rights in the Article 29. Such limitations as are determined by the laws solely for the purpose of securing the due recognition and the respect for the rights and freedom of others, and of meeting the just requirement of the morality, public order, and the general welfare in democratic society. So maybe that the freedom of expression to deny the democracy, or that to deny other freedom, or to destroy or to damage the public order or general welfare or morality can be restricted. So in this context, for example, the Germany restricted the freedom of the expression, which supports the Nazism or anti-Jewish or genocide, etc. So maybe this is the general reasons. And in order to, but freedom of expression is a constitutionally protected right. That's why this restriction should be minimum, and only the, only for the very, very important reasons. So that's why that the freedom restriction on the freedom of expression should not be abused. So in order to avoid or prevent the abuse of the restriction, so there is a many tests developed in the various countries, such as the actual malice test in the United States. So that actual malice test is that if the expression which contains the defamation against the public person, public figure, usually that the defamation against the public figure, it cannot be the reason to restrict this expression without any actual malice. Actual malice is that this expression rarely intended only solely to damage his personality, and without no concern about the public interest or public good, or truth. So this is a actual malice test. And according to the actual malice test, that the public figure must prove the existence of the actual malice. That's why that the person who expressed this speech is not, he or she doesn't have any burden to prove about the actual malice. So it's a very protective for the freedom of expression. And in Japan, that for example, the Japanese law provides if the speech contains the public concern and adequate cause to believe the truth, any defamation speech will not be penalized. So this is a Japanese so-called adequate cause test. And also that in the speech in general, the United States already developed the clear and present danger test. And I don't have enough time to explain what is the clear and present danger test, but maybe all the audience already know from the classes of the constitutional law. Okay, but if and now that we are considering about the restriction on the freedom of expression in the cyberspace, maybe that in order to discuss about that, we should review the certain area of the expression which have been subject to the more restriction than traditional expression. That means that the broadcasting. So everywhere that in the world, that the broadcasting has more restriction than printed media, including Japan. So because it's how to say unique characteristic different from the printed media. So and I'd like to review this point by taking an example from the Japanese case. That the Japanese Broadcasting Act provided the several how to say restriction on the freedom of the expression by the broadcasting company. So the purpose of the restriction is to ensure the freedom of expression in broadcasting by guaranteeing the impartiality, truth, and autonomy. So it's interesting. Restriction on the freedom of expression by the broadcasting company is to protect the freedom of expression. So maybe that this is quite controversial, contradicting how to say text. But according to the how to say and what's the restriction how to say imposed on the broadcasting company? That first, that the broadcasting company must not negatively influence the public safety or good morals. And the broadcasting company must be politically fair. And the reporting of the broadcasting must not distort the fact. And the last one is the broadcasting company must clarify the point at the issues from as many angles as possible, where there are conflicting opinions concerning an issue. So fourth point is especially difficult for the broadcasting company because the broadcasting company, each broadcasting company has only 24 hours per day to, and they have to share the programs within this time limit. So if they try to, how to say, clarify the point as much as possible within the limited time, maybe that the, how to say, each point should be very short. So, and the information might be inadequate. That's why that how to say, the fourth point is a very sensitive issue. But why that, and then that so because of this, that this broadcasting act very often criticized that how to say, unduly restricts freedom of expression in broadcasting. But of course, that if we consider that why that the broadcasting have to be subject to such a restriction, maybe there are some justification. First is the frequencies for the broadcasting is a limited resource. That's why that not all how to say expressor, how to say expression makers cannot participate in the broadcasting. That's why that how to say a broadcasting company who can use the broadcasting have to represent the how to the whole society, not the specific interest of the society. And also that in order to do the broadcasting, that there needs it needs a huge entry cost. That's why that if the broadcasting is fully free, maybe that the broadcasting will be controlled by the only rich person. And the second is a dependence on the advertising revenues. So that's why it's the same. So that if the free broadcasting is very completely free, maybe the broadcasting can be controlled or monopolized by the advertisers. It's the big capitals. And the last one is the large social influence, because at the maybe in printing medias, we can avoid the certain, how to say, type of the printed media if we cannot see such a expression, such as pornography or as the insulting expression. But broadcasting is go straight to the home, that each home, that each family, and people cannot avoid the sudden attack of the broadcasting. That's why that the broadcasting should be more moderate and very careful
Right,
about it. Maybe this is the justification. So, and now, but this just this, everyone already noticed that this justification is not, how to say, it's already outdated, because the frequencies in digital era, it's not the limited resources that we can use almost infinite frequencies by using the digital technology. And because of the development of the internet, that the entry cost to the broadcasting is drastically declined. And many, how to say, digital broadcasting using the such as a pay-per-view system or like other contract broadcasting system. So not depending advertising revenue anymore. And large social influence also that reducing, because now that the people has their own TV or own smartphone, and that how to say, they watching the broadcasting individually, not with family, so that the impact of the broadcasting is also drastically reducing. That's why maybe that in the digital era, that the restriction on the broadcasting is not, cannot be sustained anymore. So now that based on those arguments, as a conclusion, I'd like to discuss about the freedom of expression in the digital era. First point is that in the digital era, that the boundaries between print and the broadcasting media became blurred. So that the restrictions on the broadcasting should not be applied to the expression on the web. So some, including Japan, and some countries try to apply the restriction on the broadcasting to the web broadcasting, but this is the different. And I think that how to say, considering the characteristic of the web broadcasting, that the rigorous test as test for the printed media should be applied. So not the loose test, but the rigorous test should be applied. And if about the characteristic of the expression in digital era is first that symmetric, that in the before the digital era, that expression is asymmetric. There is one side, there are very small number of the expression makers and a large, huge number of the receivers, like the ordinary people. But now that other development such as YouTube or Twitter or TikTok, etc., that everyone can be a sender of the information and the receiver of information. So this is asymmetric. And as a result, that and also that, how to say, expression in the digital era is controlled by the sender, that internet service provider. So that's why that the expressor and the sender of expression is not identical anymore. Before that, newspaper express their opinion, and the newspaper company transmit this information to the ordinary people, or the broadcasting companies do like that. So that the sender, expressor, and the sender is identical, but now not identical anymore. So that's why that sometimes senders such as internet service provider is not concerned about the contents of the expression. They only consider about how to manage their transmission system, internet system. and how to avoid the legal liability. So, and the third one is transnationality, that how information on the internet cannot be controlled by the state anymore. And the last one is the perpetuality of the information, like a digital tattoo. Once in the digital era, once expression was made, that this expression survived almost eternally in the cyberspace. So maybe we have to consider like that. So, and how the Japanese government respond to this point. And I never say Japanese law is the best, but it's contrary, how to say, opposite. I think that the Japanese law is one of the most, how to say, least advanced laws. But I just explain that the Japanese laws. First, that in 2001, that the very early age of the internet, early time of the internet era, that the Japanese government enacted the Internet Service Provider Liability Act. And this law imposed the internet service provider to respond the claim against the damage. So, and if there is a claim against the damage for the defamation or the damage for the privacy, that the internet service provider have to be liable against that claim. So that because that in the internet, it's very difficult to identify who is the expressor. That's why that this law puts the liability on the internet service provider. This is as a result of the non-identicality of the expressor and the sender. And in 2016, that the Japanese government enacted the Hate Speech Act. But the distinction between the hate speech and the political speech is sometimes very difficult. As a result, that the Hate Speech Act doesn't provide any criminal penalty, only defined what is a hate speech act and obligates the government to reduce the hate speech. And the last one is the revision of the criminal code. By this revision, that there is a heavier punishment for insulting expression, because in internet, there are many insulting expression, and this causes some victims because they are damaged by the insulting expression in the Facebook or Twitter and other SNS such as Line. So that in response to the social claim, that the government revised the criminal code to put the heavier punishment for the insulting expression. Okay, that I think it's almost time that I have to finish my presentation. Thank you very much.
Good afternoon. Assalamualaikum. Selamat siang. Thank you, Puan. I will share now. Assalamualaikum dan salam sejahtera to the organizer, the honorable guests, our respected speakers, and to all participants of the conference. Good afternoon. Thank you for the invitation from the organizer for me to share my paper this afternoon on worker safety and sustainability in the workplace from the Islamic perspective. To start with, how do we protect workers at the workplace and achieve true sustainable organization, especially after all the hardships caused by the pandemic and recovery of businesses? We have to agree that in order to remain sustainable, organization must ensure to balance the people and the profit through periodical and long-term plans and efforts. The organization must protect the safety, health, and welfare of the workers and willing to set its goals beyond regulatory compliance. Despite this main obligation, the workplace safety matters often being disregarded. In actual, less attention is given to safety in the process of developing sustainability strategy. If an organization is serious in its sustainable programs, then it must conserve the resources, including the human resources. This means the organization must protect the employees from injury and ill health. A safer and healthier workplace can prevent death and disabilities, and when the number of illnesses and fatalities decrease, the business of the organization continues and helps in adding positive values to the organizations. In pursuant to that, what is the Islamic perspective on the issue of safety at work and how the Islamic law regulates safety issues at the workplace? As generally understood, Islam is a religion that believes in freedom, justice, and equality. Islam is a way of life that encompasses every aspect of a Muslim's life at all times, and fairness and equality are a part of that way of life. For men and women to earn an honest living is honorable, regardless of how great or minimal the work appears. Even the humblest work carries with it dignity. Islam encourages the rendering of maximum benefits to the workers, as had been enshrined in the Universal Islamic Declaration of Human Rights. Under Article 17 of the Declaration, it proclaims that Islam honors work and the workers and enjoins Muslims not only to treat the workers justly, but also generously. He is not only to be paid his earned wages promptly, but also entitled to adequate rest and leisure. For in Islam, workers are regarded as valued assets and as human resources. They are looked at not only from their physical abilities per se. They are not mere pairs of hands anymore. Instead, their status has been raised to the level of associates and partners in the productive process in any organization. Now, we may zoom to the specific duties to provide and maintain safety at the workplace, where the teachings of Islam represent the first principal guide for inviting men to observe the security and safety measures. Islam has surpassed the Industrial Revolution by centuries for calling for safety, and the Islamic look to safety has been more universal and comprehensive than the material look. It implies humane mercy and kindness that goes beyond the limited material objective as confirmed by Allah subhanahu wa ta'ala, saying in the Quran, and make not your own hands contribute to your destruction. Chapter 2, verse 195. The verse clearly shows that Islam is very particular when it comes to matters related to human living. Thus, it is important for this blessed religion impossible for this blessed religion to encourage brutality, oppression, and cruelty. According to the Islamic-based safety, establishing a safe or unsafe workplace is in terms of making a right or wrong decision. Therefore, if a Muslim owned a company and operated its business against the principle of Islam, it will find its benefits to be short-lived, surpass the Industrial Revolution by centuries for calling for safety, and the Islamic look to safety has been more universal and comprehensive than the material look. And the perfectness of Islam also engulfs matters related to human safety. Looking and pondering over to the contents of the Quran and Hadith would show that Islam has determined the basic principles which relates to human living since its inception. With that concluding remark, I would like to thank the audience today for being with us in this session. Semoga Allah merahmati semua pendidik dan penuntut yang berada di medan perjuangan pendidikan hingga ke akhir hayat. Amin. Wassalamualaikum warahmatullahi wabarakatuh.
Recording in progress.
Maaf, suaranya kurang jelas buat saya. Ya, konnichiwa. Ya. Ya. Mhm. I mean that the modern law, the traditional. Yes, yes, yes. Yeah, your question about my presentation, that I use a traditional understanding about the freedom of expression. So that your question is about this, or your question about the, how to say that, traditional non-Western law in Japan. I want to clarify your question. About my presentation, I use the traditional understanding of the freedom of expression. The importance of the freedom of expression is, how to say, traditionally, that in the modern European countries, including the United States, that freedom of expression considered as one of the human rights. This understanding already expressed in the such as how to say charter statute of rights in the United Kingdom in 1689, and also the French Declaration of the Human Rights in 1789, or the US Declaration of the Independence in the very close to the French Declaration of the Human Rights. So that the IU, and then that they consider that the freedom of expression is one of the traditional human rights already recognized since before, when the modern legal system has developed. But this freedom of expression is supposed mainly that the oral expression that are doing the, how to say, make a speech in front of the public, like that, or that the printed media, maybe a printed media. But recently, that how to say, along with the development of the broadcasting, because of the unique nature of characteristic of the broadcasting, that the broadcasting, many people suppose that broadcasting should be subject to the stricter restriction than traditional media such as the printed media or oral media. So so in this context, I use the traditional understanding of the freedom of expression. So that in this case, in this context, that the traditional, I mean, is not contradicting with the modern legal system. So this is my answer to your question first. But if your question about how to say traditional non-Western law in Japan and the modern Western law, that is the answer is completely different. But I think that how to say Japan successfully introduced the modern Western law since the end of the 19th century. But maybe Japan already became the one of the most advanced westernized Asian country that recently, even though that now that Japan suffered the economic depression again. So, but I never say that the Japanese law completely same with the Western law, because that we found the many how to say situation where that Japanese law, there is how the mismatching between the Japanese society and the Japanese law nominally. So, for example, the status of women, that even though the Japanese constitution provides the gender equality, but there are many, how to say, scenes that women's law is very restricted compared to the men's law. Or how to say, such as how to say our Professor Rosanna discussing about the labor's rights. But in Japan also that how to say companies culture of the company it's the very restrictive against the labor sometimes because that many company consider that they are like a family, not the how to say the place of the contradiction between the employers and employee. So that's why that even though Japanese law provided the labor's rights, but how to say the realization of the labor's rights is very limited because they consider that a company should be like a family. That's why that they should consider that how to say the interesting contradiction between the interest of the employers and the employees should be considered in the longer term, not the short time. So maybe this is how to say. I hope that this is the answer for your question. Thank you very much.
Terima kasih.
Kembali terima kasih Ibu Din.
wabarakatuh. Ibu dan bapak yang saya hormati, alhamdulillah rangkaian kegiatan lapangan
Recording stopped.